session right now. Moderator for this session will be Mr. Pramod Nair, founding partner, Arista Chambers. Pramod is a dispute resolution specialist with extensive experience in commercial litigation and arbitration. He is also a Mcia Council member. Panelists for this session will be Mr. Dipen Sabharwal, partner, White & Case. Qualified to practice across 3 continents, that is India, England, and Wales, New York. Dipen heads White & Case's EMA Dispute Section for International Arbitration. He has recently been bestowed with the prestigious Queen's Counsel title by the Bar of England and Wales. Then we have Mr. Gaganpreet Suri, who's a partner with PwC, a chartered accountant by profession. He leads the forensic practice at PwC. We also have with us Ms. Sherina Petit, partner, Norton Fulbright. She's head of India practice. Sherina was awarded the Professional Advisor Award at the 3rd Indian Annual Awards 2019 by the India Business Group. Then we have Mr. Steve Harris, Senior Managing Director, FTI Consulting. A fellow at the Institute of Chartered Accountants in England and Wales, Steve is based out of Dubai, having founded FTI's Accounting and Valuation Expert Witness Practice in UAE. We also have Mr. Zameer Nathani, Senior VP and General Counsel, UFO Moviez Limited. He's presently Senior Vice President and General Counsel for UFO Moviez. He's also Honorary Member, CII, National Committee on Regulatory Affairs, Chairman, Entertainment and Media Section, INBA Chairman, and Chairman, Global General Counsel Section. So may I please invite all the panelists and the moderator to take over the session?
Good afternoon, everyone, and welcome to the first post-lunch session today. We're going to keep this session as an interactive one. It's more of a dialogue rather than any formal presentations. And the topic for this session is it time to legislate the use of experts and third-party funding? And that ties in quite well with the theme of the conference, which is blazing new trails. The Indian Arbitration Act has made a number of innovations, some of which are unique, some of which are unprecedented. But one gap could be that it has no regulation for other persons who are very crucial to the arbitration process other than the parties in the council. And that's the use of experts and the role of third-party funders in the international arbitration process. So the question that we're going to deal with is it time to regulate the use of experts and third-party funders? And if that is necessary, how do we go about doing it? And we have the benefit of a cross-section of views on each of these topics on this panel today. So without further ado, we're probably going to plunge right in. So I think many of you who've been involved with arbitration would see that the use of experts, delay experts in the context of construction claims, quantum experts in probably every kind of arbitration, forensic accounting experts, the quality of construction experts, et cetera, have become a regular feature of international arbitration. And the question that is often posed is, how does one go about securing the impartiality and independence of party-appointed experts? And the reason is parties pay for experts who are party-appointed. The party-appointed experts work very closely with parties. They are essentially brought in because they help to establish an issue in dispute in the proceedings, and usually in favor of the party that appoints them. And considering that dynamic, how does one also ensure that the testimony of experts is also independent and impartial? So, Sherina, if I could ask you that question as to how does the international arbitration community view the role of party-appointed experts? And what kind of soft law or other good practice guidelines exist to ensure that experts are independent and impartial throughout the process?
Thanks, Pramod. I think I'll dive straight in there on that question and say that basically a tribunal will attach less weight or in fact reject an expert's evidence if he believes that that expert is a hired gun. And arbitrators always factor in concerns about partiality as part of their assessment on the weight of the expert evidence that is given by the expert. The English Arbitration Act 1996 and the major arbitration institutions and the IBA rules on evidence all contain certain buzzwords when it comes to impartiality and provisions regarding that, giving the arbitrator the discretion to decide the admissibility, the relevance, and the weight of the expert evidence. Now, these three words, I actually looked at a couple of the rules to compare it. It's quite interesting. If you look at the UNCITRAL rules, Article 27.4, it talks about the tribunal having the power to determine the relevance, materiality, and admissibility. So exactly the words that I've just talked about. Mcia Article 16.2 says the tribunal shall determine the relevance, materiality, and admissibility. So again, the same words of all the evidence. And again, Mcia Article 16.4 says that the tribunal may, in its discretion, exclude cumulative or irrelevant testimony. LCIA rules also talks about admissibility, relevance, and the weight of expertise, and also goes on to say about that the tribunal has the power to determine the time, manner, and the form in which an expert should give testimony. Usually when I am drafting instructions to experts, I generally tend to look at the CPR guidelines the civil procedure guidelines, because I think they're extremely good in giving useful guidelines for arbitration as well. And we include those in the instructions, which includes the duties and the obligations that experts should have. In essence, experts owe a duty to exercise reasonable care and skill to those instructing them, and to comply with all relevant professional codes. Experts must provide opinions that are independent, regardless of all the pressures of litigation. And I've had situations where I have seen clients pressuring experts to come out to a certain view. In fact, there was one particular case where the client believed they had a 400 million claim, and the expert actually believed they had zero. It was a difficult task when we sat down in these meetings, and it really proved the independence of this expert, because he sat before the board of this company and said, you are the claimant, you brought this claim, without actually looking at expert evidence, before actually looking at the quantum, before you brought the claim. And you're now stuck with a claim where you have said that it's 400 million, but actually we don't assess it. What was the client's reaction? Let's go to the next expert. Let's go. There must be someone out there. We went to the next expert, and they came back and said, well, maybe not zero, but maybe 1 million, but definitely not 400 million. So we went back to expert number A again. And then we kept expert B as the shadow expert, which I know we'll be coming to as well. So in terms of duties and obligations, experts should confine their opinions to matters which are material to the dispute, and always disclose all material facts before them. I do have a war story when I talked about the hired gun. There was a particular case where we were acting for a US client. The other side was Pakistani. And they had brought in 2 experts, and they'd actually provided written evidence of 2 experts. One of the experts was one of the big accountancy firms. And the second expert on the same topic was a single individual accountant from Pakistan. So the accountancy firm went in, we cross-examined him, fine. After that, and frankly, they didn't need 2 experts, but they obviously thought more the number better. The Pakistani individual went in, and whatever he said on the stand was actually quite different to what was written on paper, to the point to which the single tribunal turned around and said, we could see the level of irritation with the tribunal. And finally, the tribunal just lost it and said, who has signed this expert report? Is that your signature at the end of it? And, we knew it kind of won that case. And actually, that got recorded in the award as well. So there you go with the war story.
Thanks, Sherina. One of the topics that you very, very briefly alluded to was the use of shadow experts. Do you see that as quite a common practice these days, where parties use experts who may not then present testimony before a tribunal, but who operate behind the parapet? And if that is increasingly common, is there, for instance, a duty to disclose that such an expert is involved, for example, to check for conflict, probably with members of the tribunal?
I don't think there's any real policy that all members of a legal team should be disclosed. But when we do have shadow experts, obviously in very complex construction cases, complex valuation cases, and quantum cases, it's always, we think if, and that's something we do recommend to the client, that is money worth spending, because then you do have an expert who's on your side, you're not compromising the independence and impartiality of the expert that you're going to put on the stand, but actually you've got someone on your side who understands that complex question and can help you, guide you to asking the right questions to that to the real expert who's going to be on the stand. Obviously, the shadow expert can't stand as expert witness. We do, in practice, always check conflicts anyway to see that there is no conflict at all, and in case there has to be some disclosure made, then it is conflict-free. But as I said, it's very, very useful in complex cases. It's also sometimes useful. I've just given this one example when I was speaking about having this shadow expert. We had another arbitration as well, where the client came to us. They had already commenced claim. They had gone to another expert as well just before they'd commenced the claim. That expert had actually given them, when we assessed it, a wrong quantum valuation. And we suggested that, and we frankly didn't think that expert was independent either. So I was reluctant to kind of get involved. And I suggested, let's get a shadow to have a look at what the expert had been provided. And actually the shadow expert came back and confirmed our views about the lack of quantum in the case. And it actually helped the client make the decision to settle the case rather than run with the case.
Thanks, Sherina. I think historically, the common law approach compared to the civil law approach in respect of appointing experts have been quite different. The adversarial common law approach has been that each party introduces expert evidence in the proceedings, whereas in the civil law tradition, the expert is usually appointed by the court. What I think modern international arbitration practice has done is to fuse these two approaches and allow each party to appoint their own party-appointed experts. But at the same time, there is a residual discretion available to an arbitral tribunal to appoint party-appointed experts. And that creates, again, a very interesting dynamic. So if I could ask the two experts in the room to provide their comments on the pros and cons of having party-appointed versus tribunal-appointed experts.
So maybe I can go first and then Steve. With all the complexity in international arbitration and arbitration generally, it's not surprising to see experts coming more and more in the crosshairs now. And talk about independence, impartiality, when you talk about even shadow experts today, our world is becoming equally complex. We've had situations, and I've been in situations where I've been a tribunal-appointed expert, and then under the IBA guidelines, we've had party-appointed experts come back on the tribunal-appointed expert. So, sometimes you just really feel that is the end really in sight? when you keep adding to the mix of what you want to achieve. So, that is really creating a lot of complexity in our world. And the challenges that come with it, different interpretations, different numbers, completely different approaches, in certain ways. Party-appointed experts, at least today in my view, when you sit across a table, you can, in certain ways, through conferencing, through hot tubbing, you can at least get down to the issues you don't agree on and the issues you agree on. So there is some semblance to where the areas of disconnect are. But more and more as we go down the road, we see increasing complexity coming out of it. Tribunal-appointed experts, in my view and in my experience on being a tribunal-appointed expert a couple of times now, is adding to the complexity, and especially to the fact that when parties can come back and you are again under a cross-examination by party-appointed arbitrators on the work you submitted as tribunal-appointed arbitrators, I think it just adds more issues to deal with in terms of determining the final outcomes. So I think, our complexity has only gone up.
So,
Steve, let me just pose two additional questions there. So if you have two party-appointed experts and the tribunal decides to intervene and ask for the appointment of a tribunal-appointed expert, is that really a vote of no confidence in the party-appointed experts?
So there are two situations, yes, possibly, I would suppose. I mean, I think there are, certainly certain disciplines and certainly certain cases where the issues are so complex, that, arbitrators, as knowledgeable as they are, need a certain base of knowledge in order to evaluate expert opinions, especially when they're diametrically opposed. I mean, in the field of damages and valuation, I don't think it happens that often, maybe sometimes on particularly complex valuation cases. But, I could see situations, in engineering or science or medicine, perhaps, where in order just to evaluate the expert opinion, you do need some specialist guidance. And whether that guidance takes the form of a tribunal-appointed expert or an expert who's appointed as a member of the panel in relation to a particular aspect of the case, I think that can make sense. One thing I would say about the system of party-appointed experts and comparing that to a tribunal-appointed expert, firstly, I agree with Gagan entirely that, because of the requirement for party autonomy, it rarely results in a simpler situation because parties still want to appoint their own expert and influence the proceedings in that way. And my view is that the competitive nature of expert evidence, the fact that it is a dialogue between two experts, is one of the most important safeguards in the process of international arbitration, to maintain the quality and the independence of experts, because it is the most robust check you can have on an expert's opinion for an opposing expert to criticize every aspect of that opinion. And I would worry that might be lost, in a sense, with a tribunal-appointed expert.
Thanks, Steve. I think concerns have also been raised if the tribunal takes on a very proactive approach and then decides to appoint its own expert. That is really possibly a vote of no confidence in the party-appointed experts. But either in addition to party-appointed experts or instead of party-appointed experts, if a tribunal-appointed expert comes into the picture, then is there a risk that the tribunal-appointed arbitrator may then virtually act as the fourth arbitrator in the room? If I could probably ask Zameer to probably start off with his comments on that.
Yeah, in fact, so that's what the issue we really face when, especially you have an expert who's also a qualified lawyer, and then, gradually while doing his job as an expert, he turns also into advocacy. So that's how the bringingness of the fourth arbitrator comes into force. But as a thumb rule, whenever there is an expert in place, there are 3-4 criteria, thumb rule, which we reveal to the experts so that they are not diverted from the jobs in all honesty. So one is about the conflict of interest, which is for the experts. Second is factual reporting. Third is avoiding assumptions, biasness, etc. Fourth checklist we have is avoid advocacy in the process. And fifth, among the arbitrators who are appointed, we always advise them that, when you consider an expert in position, consider the complexities of the matter, your cross-border transactions, and the evolving technology which is involved in the process. So when you appoint an expert in a role, he is a fit in that case in terms of the competencies which are existing. So yeah, that's what the checklist speaks about. Avoid advocacy so that you don't turn an expert into a fourth arbitrator. That's my point. Say on that.
Do any of the other members of the panel have views on what could be done to ensure that a tribunal-appointed expert does not really act as a fourth arbitrator? For instance, one thing that we see is that there are very clear regulations in terms of prohibiting ex parte contact between tribunals and a party. Would it help if there are also regulations which provide that an expert cannot have ex parte communications with the tribunal without the parties being present? And are there any other approaches to ensure that the role of an expert is only to provide expert testimony and not to really decide the issues in dispute in the proceedings? Dipen?
Sure. So I think it's a somewhat similar situation to the use of tribunal secretaries. You can have as much best practice, you can have as much regulation, but ultimately what happens in a deliberation room or what goes through a tribunal when they're starting to draft an award, it's very hard to exercise mind control. And I think there is a risk, and I think which is one of the reasons why adversarial common lawyers are instinctively uncomfortable with the idea of tribunal-appointed experts, is the idea that even if you subject them to scrutiny, even if you have a chance to sort of, if not cross-examine them, make submissions to them, there is a risk, as we've seen with the allegations associated with the now infamous UCOS award, that once you get the award, you see, has it been just cut and pasted, and has there been a proper application of mine? And you can have debates about that. Just to give you an example, in the UCOS award, where there is an allegation that the award has been drafted largely by the tribunal secretary, linguistic experts have analyzed writing samples of the tribunal secretary to give expert evidence to the effect that the words used are not of the tribunal members, but that of the tribunal secretary. So that's a level of scrutiny that can conceivably be applied, and I just don't think there is an effective way to police that.
Thanks. Just moving on to another topic of ensuring that the tribunal has everything it needs to reach a proper decision in the case. And one frequently expressed frustration of arbitrators is that it's very often difficult to go by expert reports, because two expert reports are often like ships passing in the night. They deal with completely separate issues. They reach different conclusions simply because they don't deal with the same subject matter. They don't take the same data as the basis of evaluation and so on. So Dipen and Sherina, since both of you also act as arbitrators, what would you do as a proactive arbitrator if you have a situation where you find that the experts are not really engaging with the issues in dispute in the proceedings? Would you, for example, order an expert conclave to make sure that they sit down and they narrow down the differences between them and make sure that they address the same issues? Or would you rather that the matter be deferred to the hot tubbing stage, where you probably have more control over asking more pointed questions to the experts and making sure that you get the assistance that you need?
So a couple of techniques that I've seen deployed very effectively in arbitrations, which I can share. I think one is tribunals that are engaged right from the outset and do not allow the introduction of expert evidence just pro forma, but compel the parties to identify the specific areas of expertise and the issues on which they wish to adduce expert evidence, such that there is some meeting of minds right at the outset, and there is clarity on that. So I think that can be done at the terms of reference stage, or it could even be done after the submission of the statement of case. The second is another technique that I've seen in a construction arbitration where once the first exchange of expert reports had taken place, the tribunal circulated a draft list of issues and differences between the two experts and invited them to comment on that to try to finesse and ensure that the reply and the rejoinder reports are far more focused and are on point. But I regret to say that these two examples, which in my experience work very well, are much rather the exception than the norm. The standard procedure is expert reports are submitted, and then, I say this, I act as an arbitrator myself, you have an arbitrator reading in a week before, and you send an email saying, can I please receive a joint expert report setting out the experts' differences? And really, that's a burden on counsel. It's not really an efficient use of time, and it really does not help advance the narrowing of issues which you really need to make an informed decision.
I agree with Dipen. I mean, I've seen, the usual course that we've seen is similar to what Dipen said, where you have the exchange of expert reports, and this is all recorded in the procedural timetable, and then you have a meeting of the experts to decide the issues or not that they agree and disagree upon. One of the stages that we do tend to put in the procedural timetable before that meeting of the experts is actually us approaching the tribunal and asking the tribunal that could the parties narrow down. If we do find that the expert reports are quite different, then to narrow down the issues, if the parties could make submissions on narrow down the issues so that the meeting of the experts is actually quite an effective meeting. Coming to hot tubbing, yesterday Nick Peacock and I were on a panel where we spoke for 45 minutes about hot tubbing of experts. And I think the general view was that hot tubbing is not really seen much in India, and it's not that popular elsewhere in the world, though it is catching on. And when we do interview experts, we do ask them the question, have you hot tubbed before, in case the tribunal decides that they wanted that they want to have hot tubbing as part of the expert evidence bit. But I think one of the big challenges with hot tubbing is ultimately challenge, because you've lost control. You as counsel have lost control of that expert, and you put that expert into the hands of a tribunal who is going to question that expert in the tub, those two experts in the tub. And ultimately, you're leaving it to the discretion of the tribunal, who hopefully should have read the issues, and as Dipen said, it's a real problem if the tribunal has started reading a week before, and actually doesn't have that expertise to question the expert, because he hasn't lived, breathed, eaten that case like counsel has. So what is going to happen to that ultimate award? One party is going to be happy and go away. The other party who hasn't won is going to say, well, how do I challenge this award to have another bite of the cherry? Aha, well, this might be it. I don't know, Gaganpreet, you were on the opposite side of me on an arbitration. Yeah. So.
Actually, and maybe on behalf of the experts, I just want to weigh in on this. For us, it's a big source of frustration, and we get criticized a lot, especially for ships, passing at night. I think it is very important to understand from our perspective where we see things. And it really goes back to the point, and really earlier on in the arbitration, when the scope for involving experts on either side is being done, what instructions are given out to the experts, and what are the experts really appointed for? Whenever we've seen instances of hot tubbing, and both Steve and I have been in quite a few of these situations, we sit with other experts all the time. It's very important to really understand what is the objective you're getting the two experts to sit together on. If one expert has been commenting on apples and the other's on oranges, you're going to have two very different fruits with no commonalities coming out. And that's really happens, because you've got one expert who's done a claim, one expert who's done a counterclaim. The claim and the counterclaim may be, complete opposite ends, or maybe talking about completely different things. And getting someone to hot tub on those issues, you're going to have a list of issues which is going to run into pages where people are not going to agree on anything because they're talking about different things. And I think this is where our frustration comes from, and this is where we get pressured a lot from tribunals, from parties, from lawyers, why are you not coming to an understanding? We thought, this was your approach. But it is not, because our instructions were to do something totally different. And I think that's where we see a huge, huge disconnect coming in.
So I mean, I would agree with that and, sympathize with some of the circumstances you've outlined. I mean, so hot tubbing and joint statements can narrow the issues for the tribunal, but it's very much towards the end of the process. Experts can have quite entrenched positions by then, and whilst it might help the tribunal, it doesn't necessarily help the parties, to make the proceedings more efficient. I agree that the issue of instructions is absolutely key. I think that the procedural timetable is absolutely key as well. The simultaneous exchange of expert reports, in my experience, is kind of rarely useful. The sequential exchange, creates a dialogue between experts and is much more likely to result in experts, focusing on common ground. And similarly, in my experience, I know there's, lawyers have lots of good reasons for lots of things which I don't understand. But the memorial style, whereby pleadings are submitted at the same time as expert reports, also helps, because it means that lawyers are focused on legal issues that relate to damages, that help provide the parameters for an expert opinion, and they're all thinking about that at the same time. Whereas otherwise, you often get the stage whereby experts aren't really quite sure on, the relevant law that should inform their approach to damages. Then the opposing expert isn't quite sure, and the lawyers aren't quite sure because they never really thought about it. And I think it can become quite muddled.
Thanks, Steve. Dipen referred to the UCOS case, which probably brought into stark focus the role of a tribunal secretary. And I think that's probably the black swan moment, because it's something which also made institutions sit up and take notice. And many arbitral institutions across the world now have very clear regulations in terms of what a tribunal secretary can be and cannot be used for. Have you reached a similar black swan moment for the regulation of experts in international and domestic arbitration? Is there need for greater regulation? And if there is a need for greater regulation, how best can we do it? Should it be done by national legislation? Should it be done by arbitral institutions? Or is self-regulation the best thing? Or with most things in arbitration, is soft law your best bet? And it'll be interesting to hear from each of the panelists as to where they stand on the issue of greater intervention in the regulation of expert testimony in arbitration. Maybe if I could start with Dipen.
Sure. So my view is, and I think it goes back really to the title of our session, saying, is it time to legislate the use of experts? And I think my short answer is no. There is adequate soft law in the form of the IBA rules on the taking of evidence, in the form of the Chartered Institute Arbitrators protocol on the use of party-appointed experts, that gives sufficient guidance to both tribunals, to counsel, to parties, as to what is the customary practice, what is the fair and effective way of adducing expert evidence, and what is acceptable. And really, there is enough flexibility, therefore, available to tribunals, parties, and counsel to actually use these guidelines and protocols and make it adaptable for their case, rather than having a top-down, one-size-fits-all legislative mandate, which I think would over-regulate and over-burden and take away one of the great advantages of arbitration, the fact that it is inherently flexible. And don't take just my view for it. I think Justice Patel yesterday at the dinner said that we must ask the men and women of commerce what is that they want. And my firm, Whiting Case, along with Queen Mary, conducts an international arbitration survey. And in 2015, we asked the users of international arbitration the specific question: what do you think of the soft law? Do you think it's adequate? Do you think there should be more regulation? And 74% of the respondents said the current soft law is adequate and sufficient for purposes. So I don't think there's a crying need from the users, and therefore we as lawyers should be reluctant and tread softly before over-legislating this field.
So I kind of agree with Dipen. I think absolutely from a legislation perspective, I think we're good. However, and I may sound controversial on this, I think our our current structures don't really have any demeritors or anything for an expert who's not impartial or who's done a bad job. And I think that's where, self-regulation may not necessarily hold good. But, if we've seen enough cases coming up where experts are conflicted, experts have done a pretty shoddy job, but, other than the fact that their testimony has been thrown out, there is little to add back to the quality of the overall expert testimony industry as such. So I think some self-regulation, some guidelines, we've not really seen an expert's body come up, while there are expert witness institutes and other things, but even if you really have to go back and, maybe pull an expert up, there are not enough avenues to do that. So, it is something to think about.
I mean, I agree with both of you. I mean, one size doesn't fit all, and particularly with international arbitration, where you have international parties, what would be able to regulate those, those kind of international arbitration scenarios? I mean, and none of the institutional rules as well provide for that, but they leave the power to the tribunal and the parties. So there's nothing to stop the parties from writing to the tribunal or the tribunal from passing orders about the use of experts and regulating the experts that way. I mean, one of the things we see, particularly when we are working with the US on the other, US party and US counsel on the other side, is the coaching of witnesses. Now, that is something we have, because the US, there is no bar to coaching of witnesses, whereas in the UK, we wouldn't coach a witness. You'd send witnesses for witness training, but you wouldn't coach a witness. So one of the things we do practically is write to the tribunal and say, well, could the tribunal give us guidelines on what is to happen to this witness, on how parties are supposed to approach witness testimony and what is going to happen at trial, and how do you approach the coaching or non-coaching of that witness. And we've had, and it's been fine. It works out. It's there in the, in procedural orders, and it's brought to the surface the issues that the parties are facing, tailored to their case.
So I was trying to think of an analogy to express my opinion in relation to, whether or not experts need more rules to regulate their behaviour. As an expert, my inclination is obviously to say no. And I thought of two. One is doping in international athletics, and the other is, the prevalence of drink driving in the UK when I grew up in the 1980s. And in relation to both, there are laws to prohibit both of them, and there were laws at the relevant time. But either in pockets, in certain, countryside communities in the UK, or certain parts of the world in relation to athletics, the community did not take the laws seriously. It was not viewed as important to obey those laws. Now, I think that there are principles in place that establish that experts should be independent. I think it's incredibly important that experts should be seen to be independent. I think the only way to be seen to be independent is to be independent in the way that you approach your work. And I think it's the community's responsibility, the IA community's responsibility to achieve that. And from experts, that means, as you explained before, withstanding pressure from clients, when they try to mould your opinion or influence your opinion, explaining that it's not in their best interests because, the time to feel good about a high damages figure is not when you submit your report and all the rest of it. It's on lawyers to, protect experts from that pressure rather than apply it sometimes. And it's on tribunals, to call out bad experts. And it happens a bit. Maybe it doesn't happen enough, I guess.
But it gets recorded sometimes in awards as well. Of course, awards are confidential, but at least it highlights
It does,
the quality about...
And it seeps out, and there's nothing an expert is more, scared of, than being revealed as lacking independence. Nothing's more of a career killer.
So I'm not in a complete favor of a legal regulation which should be there, but I really faced a situation where I had 3 experts, and one was on north and second was on south and the third one was on the east. So one is what we tried, as Sherina also spoke out, is that we tried finding out a common ground in that. am I in favor of having a regulation by institutions? I would definitely go for that. Because at some point of time, you require guidelines. It may not be a legal regulation, but institutional regulations is required. We have things on independence and other things. We need to have some guidelines on the expert forming his opinion. Like, for example, when we tried finding out a common ground, we went to the international standards which were existing. Sorry. We went to the international standards which were existing at that point of time for that particular controversy. And that's how we tried finding out common grounds for that. So I feel there should be institutional regulations which should be put in place as guidelines. Self-regulation, we speak about a lot, but I think we consider it too much optional. If there are institutional guidelines, there is some abidance, and it's a funnel approach. So you have 3 opinions, you then go for a common ground, and then you go as per the guidelines, and by that funnel effect, you are able to come out to a particular opinion. So that's my view on that.
Thank you, everyone. I think due to limitations of time, we'll probably have to stop the discussion on experts there and move on to the next topic that this panel has been tasked with addressing, which is third-party funding, which, if it was a topic 2 years ago, would have been incredibly controversial in the Indian scene. But as many of you in the room will know today, the only question that most clients would ask you prior to who should be appointed as an arbitrator in the context of international arbitration would be, is it possible to get funding for our claim? So there has been a change on the ground, at least when it comes to international arbitration. I don't think the use of third-party funding has progressed very much in the domestic arbitration space, but I could be wrong. And I think there are different approaches to it. I mean, I think the way people would now look at it in a more mature way is that it's possible for any party to an arbitration to obtain funding for an arbitration through a variety of means. You could go to shareholders and ask for money. You could take a loan from a bank to fund an arbitration or a claim. You could seek insurance cover for a claim that is made against you. And therefore, why should third-party funding in itself be controversial? On the other hand, we've had the traditional doctrines of champerty and maintenance, which are projected as reasons as to why third-party funding is probably not permitted in many parts of the world. And there have been decisions where in some parts of the world, those doctrines have been pressed into service to say that third-party funding is contrary to the law. There are jurisdictions now like Hong Kong and Singapore which have expressed legislation dealing with third-party funding and permitting it under certain circumstances. So I think given that landscape, let me start off with a very basic question as to whether third-party funding should be permitted at all in the context of international arbitration, and probably, Sherina, if I could address that question to you.
Thanks, Pramod. I mean, you're right. Every single client, and in fact, a lot of Indian clients, the first question they ask, the second question besides who should be the arbitrator and can it be a retired judge, is about third-party funding. And about the risks, the advantages, the disadvantages. They are interested to understand. And these are not just clients who can't afford or pursue their claim. Some of these are big clients, big companies as well. I mean, I recently went to Wimbledon with one of the heads of the funds, and I was talking to this person, and the person was saying that actually quite a lot of the cases that they are getting currently are from the large companies because they don't want to tie up their cash flow in fighting litigation. They'd rather use their cash for other important investments. They don't mind paying out a little bit at the end, well, not a little bit, but whatever it is, 20% or whatever at the end, but at least for those number of years, they've got their free cash flow. I think it's helpful because the obvious thing is it helps a party in the administration of justice. I know it could lead to frivolous litigation on the flip side, but I do see clients who have come to us with a really good case. They just can't afford it. And we put them in touch with a funder or a broker, and there is a long process. It is an expensive process. Quite a lot of funders now do backroll, so that, you know, ultimately if they are interested, they will pay for that memo of merits that you had to prepare and the asset tracing as well. So ultimately, you know, if you have enough confidence in the case, then you go ahead, the client does go ahead with saying, well, go on with the merits, etc., because if the funder doesn't backroll, well, then I'll pay. You know, I think litigation and funding is there to stay, whether you like it or not. But one of the situations, I mean, on the disadvantage side, I mean, one is obviously you have to pay for the recovery, you know, and sometimes people do believe that you lose your autonomy. I was in a situation where we advised our client that they didn't have a very good case. They didn't believe us. They thought they had an excellent case. And we said, well, we don't think you should pursue, they were respondents in an arbitration, we don't think you should pursue this arbitration. Well, not pursue, we think you should try and find a way that we should settle this arbitration. They wanted to fight it, they're quite litigious. Ultimately, we convinced them that let's try and go in for mediation before you go in for the statement of case stage and money really spins out of control. And they said yes, so we wrote to the other side, another big international law firm, sensible, agreed to the mediation. 3 days before the mediation, I don't think our client was seriously taking the mediation seriously. 3 days before the mediation, when we were deciding, when we were speaking to the other side to exchange who was going to be attending the mediation, the other side revealed that a funder would be coming to the mediation. Straight away, red lights went to our client, because they realized that if a funder is on board, clearly there was somebody else telling the other side that actually our client didn't have a very good case and their client had at least about 60% chances of success. So it's, you know, so clearly the funder was singing from the same hymn sheet that we were to the client. We went in for the mediation, and there was a situation where I wondered who the actual client was on the other side. Was it the client who was sitting there who was quite quiet, or was it the funder? And so therefore, was there a loss of autonomy? The case didn't settle at mediation. The funder was very robust. It actually settled after mediation with the two of us talking, the two lawyers talking over the phone.
Thanks, Sherina. I think that's a very interesting tale. And I think people use third-party funders for a variety of purposes. And I think one message that people try to send out by disclosing the existence of a third-party funder is probably to make sure that the message gets out to the other side that the claimant has a very good case, because if the third-party funder has sieved through the claims and decided to endorse it, then that's a vote of confidence in the strength of the claim. The question then is, does this whole phenomenon of third-party funding skew the balance against respondents further in arbitration, especially in investment treaty arbitration, where a state, for instance, is the perpetual respondent? Because let's take a situation where you have a claimant who is funded by a third party. How would a respondent with no counterclaim persuade a funder to finance its defense in an arbitration? I know that's a pretty complex question, and who better to answer that than Dipen?
No, I think the funding of respondents is always a challenge. I think most funders will tell you, yes, of course we fund respondents. But if you dig deep, it's all about counterclaims. And as you said, in investment treaty arbitration, states rarely have counterclaims. And sometimes funding of respondent status is usually done as part of what is called portfolio funding. So let's say you have a big Fortune 500 company, they'll give you $30 million facility, of which a substantial chunk would be set aside to defend your claims, but the majority of it would be to pursue the claims on the basis that it would all set off against each other. So I think the short answer is that for states to get funding as respondents in investment treaty arbitration is next to impossible. But the one thing which I would say is this, that I know the conventional characterization is these capricious, evil, capitalist investors sinking their claws into states, poor states. I think in a lot of instances, you actually have some small businesses bringing claims which they otherwise would not be able to pursue in the absence of third-party funding. These are not $300 million claims, these are $10 million claims or $7 million claims. And I have seen some of those cases being funded. And I think there is a genuine access to justice issue that applies equally in investor-state cases as it does in commercial cases.
Thanks, Dipen. Do you think that there should be some sort of regulation to cap the returns that a third-party funder could make in an arbitration? Should it be capped at 2x of its investment or 3x or 4x? Or is it okay for a third-party funder to recover 100% of the claim if it is successful because it's the one that's taking all the risk? Is there a greater disclosure requirement that parties will have to adhere to in case of use of third-party funders, for example, to ensure that there are no links between the arbitrators and the funders? So I would probably just invite very quickly a diversity of views from the panel in terms of whether there should be increased regulation of third-party funding and what would be the best way to achieve that. If I could probably start with Zameer on my left.
So in the Indian context, and if you speak about third-party funding, I think it's going to be there in future. I am pro third-party funding. It's there to stay. As Sherina also pointed out that, when they had a meeting and there was a funding guy who was going to attend and there were red lights for that, I think that's the regulatory part we need to look at it. If you see in the Indian context, you have Order 25, Rule 1 of Civil Procedure Code, which says that cost of litigation, if the person is residing out of India and if he has no immovable property, the cost of litigation can be secured. So how do you secure it? Third party. So again, there is a funding. So there is a provision which gives a light to this particular tunnel. I think it can be extended to arbitration as well. Nothing in the law, therefore, stops third-party funding in that particular context. Risk which are involved, I mean, what we preach, what we practice. Globally, I've seen cases, so these are the 7 things which specifically pull out. One is your risk of disclosure, one is your third-party funding is used for blocking your arbitration, challenges on the ground of public policy, dilution of autonomy, conflict of interest, breach of confidentiality, and the most interesting part we saw in some of the global cases is that even there is a discouragement of settlement by the financer because there's a hope or expectation that we can extract more. How do we regulate that particular aspect of it? I think third-party funding, if given a legal status of it, we can put in regulation where there is some restriction on the rights of the financer. There are penalties which are involved in that. I mean, when you talk today in the context of GDPR, does after Cambridge Analytica data exchange has stopped? It's not stopped. It only regulates that and it's done in a better way. So I think third-party funding also can be regulated, but it should see the light of the day. There should be a right of termination of the funding agreement which should be given, and there should be rules regarding confidentiality and disclosure. With that regulations in place, I think third-party funding should be allowed, and it is there to stay and see the light of the day. That's my take on that.
Thanks, Zameer. I think I had invited views from all my fellow panelists, but we've just been reminded that we are out of time. But could we have time for probably taking 3 questions from the floor, and we could probably have some interventions from the other panelists in response to those. So 3 questions, and we'll take them all together and we'll respond to them together.
In fact, if I can have I'm Nitin Mehta from Ahmedabad, I practice in Ahmedabad. If I have the liberty to take all the 3 questions in one go on my own. So they're connected, so I can put in one. One is, how do you define an expert? Second is, are there qualitative criteria whereby we can decide as to who is an expert? And third is, whether in the experience of the panel, have you been questioning the status of the expert as an expert in arbitration, whether that has been a way to go ahead rather than going on merits first, you go on whether this expert is an expert at all, you can call him an expert. And last is the flaws of hot tubbing are A, the lack of preparedness of the tribunal to ask relevant questions, and B, that situations go out of control of the parties. So can there be a situation where in the hot tub you have the expert witnesses and both the lawyers on both the side actually do the questioning?
Thank you. We'll take 2 more questions in addition to those 7.
I'm Nishikant Deshpande from Pune. What will happen when an expert indicates a time limit of about 8 to 10 months to complete his job? What will happen to the time schedule under Section 29A?
We have space for one last question. Okay, there seem to be no further questions, so it gives us a little more time to respond. Dipen, could I ask you to respond to the question about qualitative criteria for an expert, and how does one as an advocate impeach the credibility of an expert report? And probably if there's a war story or 2 that you could share without, of course, disclosing names, that would be really helpful.
Sure. So I think going back to the suite of questions as to the criteria for an expert, I think I go back to what Sherina said at the outset. Ultimately, the probative value of an expert depends upon his or her credentials, experience, and expertise. And so I don't think we need to prescribe in a formulaic way as to what constitutes an expert. An expert's credentials, experience, as witnessed in the curriculum vitae and in their credentials, should speak itself and serve in enhancing the probative value of the evidence, such that the tribunal, when they listen to them or receive their testimony, are persuaded and inclined to accept it. But going back to the question, I think, yes, I think oftentimes you will have experts straying outside the areas of their expertise, sometimes perhaps inadvertently, where they may have expertise on certain areas, but in the course of giving that testimony, they may well opine on areas where they do not have expertise. And in cross-examination, it's absolutely open to counsel to impeach their credibility and question their credentials and experience and say, well, you are not really an expert on this issue, are you? And it's perfectly open. I've had a very interesting situation many years ago where it was a case involving the supply of oil and gas from Ukraine to the Europe. And there was an expert who was an academic from Chatham House, done a PhD in international relations and game theory, who gave a very persuasive expert report on the scenarios in which the supply of oil and gas would stop and it would open. But it was very obvious that he was an international relations academic who knew the entire political history of Ukraine, but had absolutely no knowledge of the business of oil and gas, and therefore was really straying outside the realm of his expertise. And we very much impeached his credibility. And in the award, the tribunal ruled that he's a very learned expert, but he was not in a position to offer any assistance of value to the tribunal concerning the questions concerned. And I think it's very much open to counsel to do that.
Thank you. Anyone to tackle the second question in terms of approaching a busy expert who is unable to commit time to an arbitration? So what would you, as a party or counsel, do? Would you look at another expert within the same organization or outside? Or if it's a really complex area in which there is rare expertise available, would you then go back to a tribunal and ask for an extension of time, and probably in the Indian context also approach the courts for an extension of time? And do these problems crop up in practice, or are we in a happy situation where there are sufficient experts available on most matters in dispute and arbitral proceedings, such that these are disputes these are issues that don't crop up quite often in practice. If I could probably ask Steve and Gagan to respond first, please.
Yeah, I can just do a very quick one on it. I think in most cases when we are asked to act as an expert, the dates are put to us and we actually give a written confirmation that we are available on those dates. So, for us, our diaries are known in that sense, and if the dates are blocked out, they're blocked out. Having said that, there are hundreds of times the dates get moved and changed, and, we live with it. I don't think there's anything. But I think, to my mind, if the timetable is set, it's set. And, most of our clients, they take it from us in writing that we're available on those dates, and it's written in our engagement letter. So we don't really have a lot of leeway on it.
So my experience is more that experts bend to fit the schedules implemented by Counsel rather than Counsel bending over backwards for the experts, which is probably the way things should be. So I was reminded with the example in UCOS around the analysis of, who wrote the award. And I suspect that, for some of the more highly leveraged experts who are around, Counsel may get somewhere from adopting some analysis to work out, exactly what proportion of the reports the experts wrote themselves. But
Thank you. I'd asked for 3 questions. I've got the third question through a WhatsApp message. So I'm going to pose that to the members of the panel. And the question is very interesting. I think the question is, can confidential or privileged documents be lawfully shared with an undisclosed third-party funder? Probably something to think about, and probably something that we can come back to after we are all woken up by coffee during the break. But thank you so much for the questions. Thank you to all my panelists for some very excellent interventions, and I request all of you to bring your hands together in the customary manner.
Thank you.
Thank you.